Thank you for listening to Lone Star Community Radio. This program was broadcasted and recorded live from the LSCR studios in downtown Conroe, Texas. Lone Star Community Radio is supported by listeners like you. Donate and sponsor today. For more information on getting involved with Lone Star Community Radio, contact us at lscrstudios@gmail.com or visit us online at www.irlonestar.com.
Hi, welcome to the Legal Connection Show. I'm Tony Collins, and I'm an attorney in Texas. And the Legal Connection Show can be heard on FM 104.5 and FM 106.1 on Tuesdays from noon to 1. And if you miss the show, and the show's premise is to help the public with some of their legal issues, like a Texas law help kind of thing. If you miss it, you can go to the legalconnectionshow.com. We have a webpage. You can also go to, it'll come up under YouTube. You can also go to Lone Star IR, it's Lone Star Radio, but it's irlonestar.com, and go to the Legal Connection Show, and all of our past shows for the last few years will be there, and you can look under it by date and I think even by topic, and you can learn about what you need to do if you get a DWI or to protest your property taxes and various other legal issues that we've covered. And so today's show is going to be on some property cases that I think will be interesting to our viewers initially I was going to do one on commercial leases, and I might kind of hit on that because it involves property. But I'm involved in a master's program at Texas A&M to learn how to be a land developer, and I'll be done with that in the spring. But it sort of led me to the conclusion that a lot of listeners and viewers might be interested in some of the actual cases and the things that I'm going through and I'm working on, so that you can learn from my mistakes. Okay, so what I'm going to start with is that a lot of our listeners and viewers may know this, but I am a trustee of a trust that owns a property on 1488, and we currently have that for lease. And through the years, the property was acquired in 2000, and that in 1999, and then later built in 2000. Throughout the years, 1488 has become extremely prolific. It started out as basically just a two-lane, not a dirt road, but a paved road with trees up and down it. 22 years ago in 2000 does not sound that old to me, but I know now that 22-year-olds are graduating from college and in my graduate program. So it's been a while. So if you remember 2000, then you're close to my age, and never fear. You've got the way I like to quantify this is if you've 40 years is 14,000 days roughly. So and on my master's program, one of the key things that they always talk about is you have to have a plan. If you in life, John Mayer says, "Am I living it right?" In his song, Georgia, why Georgia, why? If you have a plan, it makes life so much more enjoyable. And if you want to pursue a goal and be successful, then you really should write those goals down, because in your head it's just sort of a quandary and a thought and sort of a manic thing that you're just thinking about. And a lot of people go forward with just a thought, but it's so much more efficient, particularly if you're going to become a master at it, which I guess that's what the master's programs are, and in any field, is you need to write those goals down. Once you write them down, it weeds out some of the things that you need to do to make it a concrete plan and design. And then you can ask for help, and you can show people your plan and that kind of thing, and bankers love that. And so writing things down is really, really important. And so going back to 1488, because we have this building that a commercial building, it's something that I've been doing my internship projects on for this program, and our plan to. It's this semester where I'm actually doing the projects. And so a few of the things that have come up are, commercial leasing, commercial landlord-tenant issues, construction issues, when you go to market. And so I'm going to talk today about two of the cases that we have that are directly associated with the property that we have on 1488. And the property is the Big Red Barn. It's been there about 22 years, very, very prolific. And one of the things that I had to learn in the master's program when I was doing these various projects on these sort of sample learn how to develop land projects is, how to work through all the quagmire of the government information and the rules and the things you have to look at prior to developing. And I will throw out there that there's 6 really, really most important major things that everybody needs to know about before they think about developing land. And that would be either at the space market or the commercial market. I forgot what they were, but space markets when you actually develop in the commercial markets, actually the equity and the money issues, and what you need to do to get that funding and what have you. But the first and most important thing you look at before you do really any investment in land is are these 6 elements. And I kind of laugh because I thought these really aren't 6 elements. There's only 2, and everybody's heard them before. But it's location, 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 and that is so critical when you're looking to develop. And the next 3 are time. And because timing is everything in life and particularly in investment, because if you buy land and everything looks right and you've gone through all the metrics and you've gone through all the models, spreadsheets, and you've gotten, all of the gurus to tell you what you need to do and get your money and all that stuff. If you don't time it right and the market goes south like it did in a lot of people, if you're too young to know this, you would know it. But in 1998, and even as far back as 71, I suppose, with the oil crisis, oil embargo with Iran. But 1998, 2008, even now with COVID. And so what you need to do is you have to look at the financial markets and sort of what the consumer price index is to find out what your discount rates are and how much money you want to put into it and how you're going to fund it. And, if you find the right project in the right location and the right time, you will always find investors and you would put some of your money into it, but it's always best to use other people's money. Okay. That all being said, the topic going, back to what the show's about, I had the idea about our billboard. We put a beautiful billboard up on 1488 close to the Home Depot about 4 years ago. And that billboard is, you can make quite a revenue stream from having a billboard where you have enough vehicles going by it. And you can find the number of vehicles that pass in front of a particular location by going to the Texas Department of Transportation. They have all this just amazing amount of information for all over the state. You can just zero in like on a Google Earth map and be able to pinpoint the number of vehicles per day that go by a particular location. And it may not be your exact location, but it'll be pretty close. The problem with this particular map that the Texas Department of Transportation has is that it's not updated in the different areas all the time unless it's a major intersection, major thoroughfare at a particular location, or if they're doing a test at that site for one reason or another. And so where our barn is located, it shows the most current update was in 2016 that showed that about roughly 44,000 vehicles per day go in front of our commercial location. Now, to put that into sort of a perspective, back in 2000, you could ride your horse down 1488 and you could run out of gas and you wouldn't have a lot of help. You'd have to walk 5 miles one way or the other, and you wouldn't have had a lot of, I don't know what the vehicles per day would be, but it may have been 5, it may be more, but it was not as many. And so it made me think about the history of 1488. So roughly, I'm going to tell you about that. Then I'm going to tell you about a case that we had that all started because of this particular barn location, and how you learn in life through trials and tribulations. And I truly believe that when you talk to St. Peter at the pearly gates, because we all are going to, it's a fact that we will not live generally past 100 or somewhere in there. Your quality of life really fails after that. But we are all going to pass at some point, and so you want to work toward what God's intention was for you to do in life. And I firmly believe, and I think it's it's like a tenet of many Christian religions, and I think many other Muslim and different religions as well, is that one of the biggest things you need to do is and what I say at the end of the show is serve others. You really need to be thinking about what you need to do to help other people, because God wants us to love one another. And I think that that's going to be what God sort of tests us on. That's a part of what is looked at later, is how did you handle adversity, and how are other people affected by the way you handled it? So no matter what bad things may happen in life, if you can just, weather that storm and sort of look at it in the perspective that this is a fun challenge, a part of the journey, as opposed to, this is dreadful, what am I going to do? This all kind of goes back to why I'm talking about this billboard. But before we go there, let me tell you about 1488. And this is just a very brief history on 1488, which I didn't know and I thought was really interesting, and I think y'all might too. FM 148 is located, and this is the wiki on it, and you can find this on any street, on any thoroughfare, artery, and what have you, is located in the greater Houston area. It is at its western terminus is at the intersection of Highway 290 and Hempstead. And it travels east-northeast, ending at Highway 45 between the Woodlands and Conroe. The road travels through rural parts of Waller, Harris, and Montgomery counties, and directly through the town of Magnolia. FM 1488 was designated on July 22nd, 1949. So if you go to Google Earth Pro, which I highly recommend to everybody, it is so fascinating. It's a free application. You download it. You can pull it up, and Google Earth Pro is different from Google Earth because it's got a little historic clock up on top. So you download Google Earth Pro for any reason to see what was going on in your land 5 years ago, 10 years ago, 50 years ago. If there was a satellite taking pictures, it will be on Google Earth Pro because it's been updated by the U.S. Geological Group, right? And so with Google Earth Pro, and specifically for this example that I'm using or telling you about, there's a little clock on the top ribbon or bar once you download it. And there's a little space in the top right-hand corner, and that's your search. It's got like a little, search, the little magnifying glass or whatever right there. You put the address of what area you want to look at. So you put your address in it. In my case, it would be, 5814, 1488. And at Magnolia, usually it will give you some options, but if you put Magnolia 77354, whatever your address is, it might be your home you're looking at, or it may be a piece of property you want to look at. You put that address in, and it will, it'll take you from the universe like you're in outer space, and it zooms right into the property, and you can make it larger or smaller, and you can even put that little yellow guy that walks, street view, and you can actually look at it if they've got a satellite that's picked that up. A lot of times they don't. And so what's fascinating about this is if you do this on 1488, you can actually, at the little timeline, the little historic clock, if you hit that little icon, it looks like a little clock up there, it will bring up a timeline bar, and you can actually use your arrows or highlight any year that a photo was taken from the galaxy or wherever, some satellite. And in Magnolia, it will actually go back to 1945, if that's just not the most interesting thing ever. Satellites were being launched by the Army during World War II, or shortly thereafter, maybe during that period. They were becoming so advanced at that point. And they've got these grainy pictures, but if they've taken the picture, you can see the terrain. And in Google Earth Pro, you can make it just the topography, or you can have a street view. You can do different things with it, and it's like an overlay. Really interesting. And so what you can do is you can see how that land has changed over the last 70 years or however long it's been a satellite. So let's say you want to go back 10 years ago and see what was on my land 10 years ago. You can look, and it'll bring you to that year if there was a satellite picture taken. Starting about 2010, there's the very, very clear satellite pictures, taken at different times during the day, but you can look at your own property. And in particular, 1488, you can watch it being expanded. It goes from, a dirt road with all trees to being expanded to, a center lane, and then 2 lanes going both ways and a shoulder. So it's 7 lanes wide, and they're getting ready to expand it again. So you can look at that. I highly recommend it because you can see how things have changed, and whether a pool was there, whether someone has gone in and improperly changed the flow of a waterway. There's a statute that says you can't do that without the permission of the Army Corps of Engineers and various other government agencies. So do take a look at that. That's my big tip for the day. But at any rate, 1488, you can actually go look, and it will show you in 1945 what it looked like, and the way the loop looked at 45 and when they were building it. Really, really fascinating stuff. This goes on to say that on December 27th, 1952, FM 1480 was extended to US 75, which it runs along the railroad tracks and it's parallel to I-45, but that was there before I-45. It was sort of the road, the international roadway that went between Galveston and Dallas, kind of like what I-45 does now. On July 11th, 1968, part of the old location of FM 149 over there by the high school was transferred to FM 1488. And on May 30th, 2019, a proposed bypass around Magnolia was designated. When the bypass is completed, the old route of 1488 will be designated as FM 1488P. And it will be a bypass that will be concurrent with the Aggie Expressway, which is 249. And they say here that it's currently under construction, but the reality is it's pretty much complete now. And if you think I-45 is crowded and your Google, little map thing is not taking this direction, take 1488 all the way out to 249. It is fast. I love that thoroughfare to get to the Spring and Tomball area. They have finished 249 going from 1488 all the way up through, I don't know, where it connects to, a 99 and I-10 and, all those different connections. I guess it goes to 249 and then it branches off to the Beltway and what have you. But do take it. It's really good. All right. So let me get to why I was telling you about this, our billboard. Back to the billboard. We have a sign on our billboard, and one side of the sign says it's putting bona fide purchasers for value on notice that there is a lawsuit with D.R. Horton, a developer that is associated with some land where they developed that they didn't own the title to. And it's undisputed that the people that owned the land, which, we actually own now, my husband and I, that they weren't served in this notice, and there was some, improprieties going on in the federal court down in Houston when this lawsuit occurred in the early 40s, once again during World War II, and they weren't properly served. And so the people that owned the land, it was the Hodge survey at the time, told the court, well, we actually own this other tract of land too, and they didn't. They lied, and so this judgment sort of was dormant was signed off by this judge without the proper notice to the actual owners for years, and so it kind of went unfettered and untouched until D.R. Horton bought the land from the heirs of the people that owned the land, which were, a pretty prosperous and well-established, well-known family in Conroe, the Maidleys and the Metcalfs, our state representative. That family owned that land, but they sold it without any liability to Horton, and so they didn't have any. They didn't have the impropriety of what happened. They were outside the loop of doing anything wrong, but it still tainted the land because the title didn't belong to them when they sold it, and so they're out of the picture. And D.R. Horton became involved, and D.R. Horton tried to say the survey didn't exist. They had it on all their plats. They came to the City Planning Commission. They said the survey does exist, and they said it didn't exist when they learned that they didn't own it. And the Texas General Land Office said it did. I mean, it's been sort of a quagmire of things going on, but that particular case is still ongoing. And they put houses up knowing that they didn't have title. And my understanding is that they, and I don't know this for sure, but I was told by different real estate brokers, and it sort of makes sense, that in order to sell or lease the houses that are in the area where there is a dispute over the title, they have to have an additional bond for that, or their own mortgage company has to put the mortgage on it because there is a title flaw, and that puts a problem with the people that they don't disclose that to, because developers don't have to disclose title problems. So there's a lot of things going on, but as an attorney, I kind of knew about it. So we went ahead, and that case is ongoing, but we put on the billboard on the notice, the prospective buyers on notice that they may need to look into this before they buy within this area. And it's basically a notice so that the people that buy in that tract of land, which is the Sieberman survey, and you can find that doing the Google Earth thing as well, because it does exist. And Horton was saying it didn't. It's another just sort of legal argument. And it's not actually a legal argument. It's a legitimate that the Sieberman survey exists and they don't own it, but it's coming down to a legal battle, which we're going to talk about in a little bit. But we put a billboard up saying, hey, did you know about this lawsuit? So that's on one side, and that case has been going on for about 8 years now. And we believe we're going to win, but that's why that notice is up there, so that 60,000 vehicles a day that live in the area will see this notice. And on the other side, I actually had a billboard that was a vinyl that was advertising this particular radio show, the Legal Connection show, that airs on Tuesdays from noon to 1. That, is a sort of a community resource. I don't get paid for this or anything, but I'm trying to do my best to help and answer questions to various listeners and people that don't have money to hire an attorney, to answer questions that they might have, which I do answer on the air if I get them. So we had some tenants before, which is another thing we're going to talk about today. And we had some tenants that didn't pay their rent. And they were a furniture company that was there for about 11 years. And throughout a period of time, they ended up getting behind to the tune of about $200,000 or more. They only paid partial payments and made a lot of excuses. And so we worked out a deal with them that they could stay in our location if they told us before they were going to leave, or they did, and they didn't move the collateral out, because that was the only thing we had to pay back the rent that they owed us, or work something out with them. And so when we went to mediation, because we actually had to file suit. We didn't want to file suit, but we did, because the statute of limitation provides that under a contract that you can't sue for a debt that's over 4 years old. And so we sued them to stop the clock on that past rent, because it was accumulating. They hadn't paid so much that it was quickly running out, that, it was always stagnant. We couldn't sue them for the part they owed, and then when they didn't pay us, it was always the same massive amount. And so they were getting free rent. And so during the mediation, when we didn't settle with them because they didn't want to pay us anything, they went to the commercial location, we learned, while we were in mediation, and they hauled out about $500,000 worth of lien-free furniture, which would have gone toward paying our rent. And so we went to trial. This is back in 2014. We went to trial, and the jury found in our favor, and they awarded us over a $200,000 judgment plus attorney's fees. So it was roughly, $250,000. And the judge at that time in the 284th, Judge Woods, I believe is who it was, she did not sign the judgment for about 20 days after the jury's verdict. And we needed that judgment signed because we were trying to find the furniture that they had taken out so that we could pay the judgment back. I mean, it was sort of like it was a timing game. And we learned during the trial that the judge actually was very good friends with the opposing counsel's co-counsel, our partner in their office. And so it was just local politics. But at any rate, whatever the reason may be that she didn't sign the judgment, it didn't get signed for about 20 days. And during that period, the Zollners, who were the proprietors of the furniture business, they filed for bankruptcy so that they wouldn't owe the judgment that we just gotten. And so I knew nothing about bankruptcy. I learned bankruptcy. I started talking to some of my colleagues in law school who who sort of guided me and helped me to learn about adversary cases. And so what I'll talk about today, and if we don't finish, and we may not, is we'll continue this in the next in the next radio show, the next segment, that just basically reads the brief, a very, very well-written brief that I had so much help writing. But it's currently in the United States Supreme Court. So just to let you know, sometimes these things can drag on for years, and you can't let it get you down, but you have to learn from the experience. Don't stop if you know you're right. Just keep on going. And, prayer really does help. And I think to a large extent, the reason that prayer helps is to put things into perspective, that God wants you to have peace. And you can't have peace if, you've been done wrong and you let it go. Because people that don't turn people in that commit crimes, and those criminals commit crimes in the future to someone else, they a lot of times live with that guilt that they didn't say something and stop it. And so we are just kind of going along with a good heart, and with not really any, you forgive your neighbors, not any, ill will, but really to make sure that justice is done. But knowing that you can have peace with it at the same time and learn from, these the adversarial procedure, or not procedure, but an incident that's going on, like we all have, with everything that seems, like it's detrimental to you. You can always make into a learning experience and something that can be for the good, even though at the time it seems really dismal. So approach things that happen bad to you in a enlightened way and with the right attitude, because more than likely you will come out ahead if you're doing it for the right reasons, with the right heart, and doing it with peace. And so that's what I was trying to do. So anyway, we had this the billboard on one side for the lawsuit with D.R. Horton to put bona fide notice, to put the purchasers on notice, actual notice, so that they wouldn't be bona fide purchaser for value, so that we could actually get the property back when we win, and which we anticipate. And then we also have them on constructive notice, because we have notices in the record. So we've got notice both ways, but I like to do both. The radio show sign was actually put on the billboard because I wanted to put the Divine Mercy Jesus on the billboard. My husband got the side that's on the east, and I got the side that was on the west. And the tenants that were there for about 6 years, Mercy House, were adamant that we don't put the Divine Mercy Jesus up on the billboard, which sort of puzzled me, but we didn't. And since they have grown out and moved on, we now have the Divine Mercy Jesus up on my billboard. But the reason that again, is important to today is because one side of the billboard had to do with a lawsuit that's been going on for about 8 years now that we have with D.R. Horton, and it's still ongoing. We anticipate, through the right procedures and with a good heart, winning that. It is currently... that particular case, I don't know if you can see this, I'll show this on the screen. It is set, or was set, for oral argument tomorrow in the Fifth Circuit. We were pretty excited about that. But, oddly, the Fifth Circuit sent us a notice after we had, and I'll put that up again. This is the forms that you see, and I didn't know that you'd even get this, and you wouldn't know unless you're an attorney that actually practiced in the Fifth Circuit. Let me see if you can see that. There's our little notice. They send you a form for you to confirm that that you're aware that they've scheduled you for, your oral argument, and you have 20 minutes, and it's all very formal. And I've had oral argument in the Fifth Circuit, New Orleans, before. It's really fun, and it's a pomp and circumstance, and you'd think they'd have little white wigs and stuff. It's just really exciting to do an oral argument, particularly in New Orleans, which is sort of my hometown indirectly, because all my descendants, came to New Orleans from the 1840s forward, and, they owned half the French Quarter. Of course, we don't, but they did at the time, and a lot of my relatives do, but that's kind of here and there. I had I guess my great-grandmother aggravated my great-great-great-grandfather, and because she married somebody beneath her debutante status, and he's like, good, you're not going to be in the will. So all of our French Quarter inheritance, basically down the pike, went to some uncles and aunts and what have you, and we still are there, and I work with them from a financial standpoint, but, to help them invest their money, but we don't have... we don't own the French Quarter like they did. But I love going to New Orleans because it's so beautiful, and we were going to go down there. But the Fifth Circuit sent us a notice really just a few days ago saying that we've decided that we can decide this without oral arguments. So we are not going to New Orleans now, and I have more fun for Labor Day weekend right here to go to the Aggie football game. Football season starts, SEC, and at going up the Aggie Expressway. We get to be there on September 3rd for the first game. I'm so excited. And another little plug, SEC Shorts. Watch those little videos. They are hilarious. It's the guys that put them together from Tennessee, another SEC school, University of Tennessee. But very, very funny. And every week a new one comes out. So just Google SEC Shorts, watch them, and just have a really fun day. All right. So anyway, we were going to argue in the Fifth Circuit. And the case we have, I'm going to read you the reply brief on it. It's going to give you a little bit better insight than what I just told you, and with much more clarity than what I just said. So that's one case. And the other one was the United States Supreme Court case we have that involved our the tenants that had the furniture store at the barn location, which was, still associated with that property in 1488. And why that we believe that we're going to get certiorari on this and move forward and win this case. In that particular case, we took him to court in bankruptcy. We actually had a full-blown trial. It lasted for months because it kept getting stopped and restarted again. The bankruptcy judge said, yeah, they're bad people, but they shouldn't have done what they did, but we still think that they should be forgiven in bankruptcy. That wasn't right. That's not what the law was. That wasn't Supreme Court law. So we took that we appealed it to the district court, the Southern District Court. You have two choices in bankruptcy appeals. You can go to a bankruptcy panel in the Fifth Circuit, or you have a choice to go to the district court. We went to the district court. Ultimately, the district court said, yeah, the bankruptcy judge was wrong. We're going to reverse this. They took the property. They shouldn't have done it. They did it willfully, maliciously, knowing that they were taking this property that was set aside to, they moved collateral that was set aside to pay the landlord his rent under contract that they knew they owed. And so that was fraud. You can't do that. And so it was reversed, and so we now had a good judgment. And then they took it to the Fifth Circuit, and the Fifth Circuit said, well, we agree completely that the wife has complete liability. She had argued, well, I didn't sign the lease, but she did, and she, I don't know why she lied about that. But ultimately, the Fifth Circuit said, we don't care. You ran a business with them. You're extremely culpable. In fact, you are culpable, and so you're on the hook. But they said, well, even though the district clerk says that they're now responsible and they can't dismiss this judgment in bankruptcy, we're going to reverse that and say that they can dismiss it because they said a state law, and it's going to be more succinct in what I read, but they basically said, we think that the word you didn't prove that they disposed of it for the definition of transfer, all legal sort of technicalities. Well, that's not what the Supreme Court says. The Supreme Court says if you take somebody's if you owe a debt and you remove the ability, if you prevent them from being paid, and it says it much more succinctly in the Supreme Court case that I'm going to read you, if you intentionally remove their ability to, let me just look at this. It's so much easier to say it right here. This is the Supreme Court law. The court holds that it is actual fraud. Let me just read this. Why should I even try to paraphrase? The bankruptcy code, the federal bankruptcy code, bars the discharge of any debt for money obtained by false pretenses, false representation, or actual fraud. And the court holds that actual fraud bars discharge under Section 523A, which is still just a technicality. And it sounds like, it's a lot to understand all these rules and where they are. It's just basically the bankruptcy code says that when a debtor has deliberately obtained money through a fraudulent transfer scheme, which is what the Zollners had done. They fraudulently transferred collateral from the barn, which they didn't pay the rent on. That was actually intended to cheat a creditor, which they did because they moved it knowing that collateral would have paid the debt that they clearly owed by virtue of a 12-person jury saying they owed it. And we had presented to them. The Fifth Circuit's decision conflicts. The Fifth Circuit decision is in conflict, which is why we were actually in the Supreme Court right now. And so the law, and this law is actually Husky, is Husky International. When you go to Home Depot and you buy your Husky tools, they are the company that was in Houston that didn't get paid by this debtor. They were called Crystallis, but a guy named, I think Daniel Ritz was his name, had moved funds from one of his entities to another so that he could declare bankruptcy so he didn't have to pay Husky like a $250,000 debt, not judgment debt, not unlike what we had. And he won in the Supreme Court. And they said basically that, not basically, but expressly, quote, anything that counts as fraud and is done with the wrongful intent is actual fraud, and fraud is a debtor's transfer of assets, like a debtor's scheme that impairs a creditor's ability to collect the debt, and it's not dischargeable in bankruptcy. And so that's basically the premise. You can't prevent a creditor from being able to satisfy a debt by intentionally moving the money that you have so that they can't get to it, so they can declare bankruptcy. And that's why we are going to win and get certiorari in the Supreme Court. That case has been going on for 10 years. So if you have a conflict of this nature, the best thing you can do is to try to learn from other people's mistakes, really vet your tenants, vet the people you marry. To let me extent, you need to check them out. Know who your partner is, people that you're leasing land from or you're renting land from. Know who these people are, because you may have to later come back and take them to court, which is the much easier way than, or settle with them. But if you can't settle with them, let our justice system step in. A lot of times the justice system doesn't get it right, but you've got to go through that sort of civil means to protect yourself. And as an attorney, I believe that, at least 80% of the time it does actually work. Okay, so I'm going to read to you we have two cases we're going to go over in this segment and the next segment. The first is the bankruptcy case, to kind of tell you what your rights are and what you need to do, and how you can kind of give it food for thought on what you need to do if you're ever in that situation, whether you're a tenant or a landlord, and you get behind on your rent, and how you can pursue that through the different legal channels. And then the other case we're going to go over is the case that we have with $27 billion land developer, D.R. Horton, and what they what they can do, will do to sell land, whether or not they actually have the title to it or not. And they're a great developer. They've got a lot of lawsuits against them, with the construction and stuff. But in this particular instance, we're looking at just sort of the actual law and what happened in this case, and the different channels of the law that you can apply when you know that, or when the facts support that they have made a mistake, whether intentionally or not, but their lawyers have carried through to try to make that mistake, and them, because they've actually are giving consent for the lawyers to go forward, they're trying to make this mistake right when it's not. And so we're going to go over that particular case too, and where it is in the legal channels and what have you. All right, so I'm going to go to I guess this is really, I think, interesting, and I want to show our listeners and viewers, if you haven't seen this. When you're in the United States Supreme Court, you have to present briefs, not just like a paper brief like this, okay? So, but you have particular fonts and a word limit and sections, and there's a format. There's a lot of protocol, and that's why you pay attorneys a lot of money to know how to do this, and it's very formal. But when you get to the United States Supreme Court level, it even gets more formal. And you've got to have it in these booklets, and these booklets were they waived the written necessity to send booklets to all the opposing counsel and to the courts and all this during COVID, but it's back on again. It's really expensive. You have to get typesetters. So the first petition for the writ of certiorari that we wrote, met all the criteria and what have you. So we sent it to some typesetters, and they had to put it into this book. And the color is white for the particular first petition. That's actually in the statute that it has to be white. It's got to be in this format. It's got to be bound like this. And so, it has to be like just so perfect. And you don't even have like a case number yet. It's all open, and they assign it. So these days, I guess that's the wrong way to put it. It sounds sort of biblical. These days, like the I forgot Mary's Magnificat. Um, the when you file it, you have to do it all online, and so you have to actually be a member of the United States Supreme Court, pay all those dues, and then you have to e-file it in a certain way by a certain time, and everything has got all these timelines and stuff. But when they require that you have that 40 of these booklets be printed and sent to Washington, D.C., so it can be distributed. And so we had these done, and then, it cost us, a small fortune, but they sent it out, and it looks beautiful. So the first one is white. And so then in this particular case, they, as I recall, the United States Supreme Court actually asked the other side to respond. That's not usual. So we thought we have a really good shot at this now. And when they filed a reply in earlier August, their reply was in an orange binding, and that's also statutory, that it has to be orange in this particular jurisdiction in the United States Supreme Court. And so we had a certain number of days before it was distributed. You can file supplemental briefs, and you can also file a reply brief. And they had made a number of factual misrepresentations and legal misrepresentations in their brief. That it's actually, if you want to look it up, it's case number 21-1430 in the United States Supreme Court. You can actually read these; they're all in the public record. But anyway, so we had to do a reply brief so that those factual and legal misrepresentations didn't stand. So it showed that we didn't agree with them and objected and rebutted them legally. And when you do a reply brief, it's actually this tan color, and you only have 3,000 words, and you're using every word. And I thought I was only going to do like one paragraph, and I ended up doing it just a little bit longer. And so in the case of the Zollner's bankruptcy adversary issue. So if you're ever in a situation where somebody owes you money and it's under contract, and you get a judgment against them, or they don't pay it, or you get a judgment in state court and you've got a fraud finding, or you get a judgment in bankruptcy court that they owe you this, you can actually and then it gets reversed or whatever. If one side or the other doesn't agree with it and it goes, up, as they say, then you can file these cases with the U.S. Supreme Court. That goes all the way up. That's pretty much one of your last channels to do it. And the first brief that you write sort of sets out, just very generically, but in a very easy way to read because they don't have much time to read it. It sets out what the factual setup is. And so I'm going to get past all of this sort of legal mumbo jumbo and go straight to the legal background and the factual background, because I think it's, to me, very interesting, and I think educational for people that may be in a situation where they've had a judgment or someone that's owed the money, and that person's declared bankruptcy improperly for the sole purpose of not paying the debt that they owe you, using the system so that the cheater wins. Completely wrong. I won't let that happen. I wouldn't let it happen to you either. But so here's the statement of the case that you have to write. For the case that we have against the Zollners. Congress intended the bankruptcy code to provide a fresh start to the honest but unfortunate debtor. That's what bankruptcy's for. Somebody that's just had, it's hard on their luck. That's a quote from a Supreme Court case, Brown versus Felsen, 1979. So the Supreme Court, that's their actual words, and I believe it was Judge Sotomayor that wrote it. In keeping with that purpose, the code provides relief for individual debtors, but also provides that they may not discharge debts from money obtained through dishonest or fraudulent means. Specifically, and it's pertinent here in this case, a discharge in bankruptcy does not discharge an individual debtor from any debt for money to the extent obtained by false pretenses, false representation, or actual fraud. And that's under 11 U.S.C. 523A2. It's really important code for fraud in bankruptcy when you're the person that's been defrauded, if you're the creditor, judgment creditor or otherwise. that 523A is where the exceptions are made, where you can be discharged of all the debt that you owe, except for you can't discharge child support, you can't discharge, your federal tax liens, and you can't get a discharge if you've committed actual fraud, like wrongful death actually falls in that category. You can't kill somebody, owe them $41 million in a civil lawsuit like O.J. Simpson did for the Nicole Brown murder. You can't get that discharge because it's morally corrupt, and our system doesn't reward cheaters. Actual fraud, though, when somebody actually takes the collateral that is the security for your debt and they hide it from you, or they take money that's in the bank that they could use to pay your debt so that you can no longer find it and discover it's not there to pay you, and they say, oh, I have no money. That's actual fraud, and they can't do that. And so not only is it criminal if you can get the State Department or the government to press charges, that's criminal. But it's really hard unless they're way high up in the vetting system of the United States, like lots and lots of money. They usually don't press charges. So you're kind of on your own civilly to protect yourself, which is what this 523A in the Bankruptcy Code does for creditors when you file an adversary suit to prevent a judgment or a debt from being discharged that was that the cheating debtor is trying to get out of, right? Okay, so the United States Supreme Court holds when a debtor engages in an intentionally wrongful conveyance scheme that impairs a creditor's ability to collect the debt, such debt shall not be discharged. And that's the new definition of actual fraud. And Husky International Electronics, that placed the same entity that you see that you're buying, your tools from in Home Depot, that was this. They won, and they got a new definition made in the United States Supreme Court in 2016, even before we filed our lawsuit, but it helped us because it happened in the interim. That was the new definition of actual fraud when there's a fraudulent conveyance scheme, like when Michelle and Bill Zollner took all the property out of the barn to move it so that we couldn't use that collateral to at least offset the debt that they owed us. Okay, so here's the factual background. Respondent Michelle Zollner rented commercial property, the Big Red Barn, to run a furniture store. She personally guaranteed payment of the rent. And this was all, just to sort of quantify what I'm saying, this has all been vetted and it's undisputed in each court. The state court, the bankruptcy court, the Fifth Circuit, they've all agreed that the facts I'm reading you they're not disputed. This is what they've said. So the facts are no longer at issue here, so I'm just laying it out for you as the courts have already agreed. Okay, so Michelle Zollner personally guaranteed payment of the rent. Dr. Collins, who's the trustee of the barn property, had a security interest in all the furniture located in the Big Red Barn, the collateral. Michelle Zollner owed Dr. Collins over $218,000 in rent arrearages that she hadn't paid from a period of about 2007 to about, at that time, 2012. It had accumulated by just partial payments and no payments. And, of course, the jury said, yeah, that's exactly how much is due. While the debt was outstanding, Michelle Zollner agreed not to remove any of the inventory from the Big Red Barn outside the ordinary course of business without notifying Dr. Collins. It is uncontroverted that by the state court, the bankruptcy court, the district court, and the Fifth Circuit, that Ms. Zollner deliberately removed, fraudulently transferred, and secreted the collateral from the Big Red Barn with a specific intent to cheat Dr. Collins, thereby impairing his ability to collect the debt. And that particular phrase has been affirmed basically in each one of the courts. So that factual background is undisputed. Now, this is what happened with the proceedings. So now you know that the facts that are undisputed, these are the undisputed proceedings, okay? And it may give you some insight on whether or not you even want to go through this if somebody owes you money. The cost-benefit analysis may not be there for you. It was for us because it was like $250,000. All right, so on August 27th, 2014, Dr. Collins obtained a state district court judgment against Michelle Zollner that was rendered by a jury, 12-person jury, after Dr. Collins' lawsuit was fully and fairly litigated. Entry of the judgment of over $228,000 immediately preceded Michelle Zollner's filing for bankruptcy in October of 2014. So in other words, she filed for bankruptcy right after the judgment hit so that she wouldn't have to pay the judgment. Michelle Zollner specifically sought through such bankruptcy procedure to discharge her personal judgment debt owed to Dr. Collins for the $228,000. Now, with interest, so much more. But for Michelle Zollner, actual and fraudulent transfer of Dr. Collins' collateral, Michelle Zollner's debt to Dr. Collins would have been satisfied, but her deliberate acts impaired Dr. Collins' ability to collect his debt, so his judgment lien, as a matter of federal law, is not dischargeable. So I'm going to read that again. So I kind of read it, with the wrong emphasis. But for Michelle Zollner's actual fraudulent transfer of Dr. Collins' collateral, Michelle Zollner's debt to Dr. Collins would have been satisfied, but her deliberate acts impaired Dr. Collins' ability to collect his debt, so his judgment lien, as a matter of law, is not dischargeable. Now, in February of 2015, so about 6-7 years ago, Dr. Collins initiated an adversary proceeding in the bankruptcy court arguing Michelle Zollner's debt to Dr. Collins was not dischargeable under the actual fraud exception of 11 U.S.C. 523 A2A. Specifically, Dr. Collins contended that Michelle Zollner defrauded Dr. Collins by literally and physically transferring all his collateral worth in excess of $200,000 to another location, then converting it for her own benefit in a deliberate attempt to thwart Dr. Collins' effort to collect the debt he was owed by her. As a result of her orchestrating and personally benefiting from this scheme, Michelle Zollner personally owed Dr. Collins a debt for money and obtained by actual fraud under Husky. So it should not be dischargeable, okay? On August 22nd, 2016, so about a year and a half later after the adversary proceeding was initiated, the bankruptcy court rendered a final judgment after a bench trial. The court effectively found Michelle Zollner fraudulently transferred Dr. Collins' collateral, but denied Dr. Collins' claim for non-dischargeability because the bankruptcy court said he failed to show that the Zollners disposed of or parted with the furniture. So they kept it, so somehow that made it right. We took the collateral and put it in our house, but we're going to keep it from you, so that makes it so that you didn't comply with all of the rules of the bankruptcy court because you didn't prove this disposed, function of that. Even though it says, despite overwhelming evidence to the contrary, including photos of Michelle Zollner converting Dr. Collins' collateral in a frenzied, nonstop 2-day haul of over $200,000 of inventory in which the court determined to be Dr. Collins' assets. Okay. Now, let's fast forward a full 5 years, almost 5 years later. This is how long it was on appeal. It just sat in the court, and you can't, make justice go any faster than they want it to. I've never seen an appeal last this long, but, it was in our favor because they read it and overturned it. So on October 9th, 2021, the district court, finding that the Zollners literally, physically conveyed or transferred Dr. Collins' secured property from one location to another to evade Dr. Collins' lien. That's a quote from the district judge, that Michelle Zollner, quote, literally, physically conveyed or transferred Dr. Collins' secured property from one location to another to evade Dr. Collins' lien. So reversed the bankruptcy court, concluding its decision was erroneous because Michelle Zollner committed fraud under 11 U.S.C. 523 A2 and A6 when she converted Dr. Collins' security with the intent to prevent his ability to collect his debt. So the debt was not dischargeable in her Chapter 7 bankruptcy under Husky, in its Husky International Electronics versus Ritz 578 U.S. 355 and in the U.S. Supreme Court 2016. All right. Now, She, on a month later, on May 10th, 2021, so we're kind of getting up into current times here, Michelle Zollner appealed the district court's decision to the Fifth Circuit. After a full briefing in an opinion issued on December 6th, 2021, the Fifth Circuit affirmed the district court, who had properly reversed reversed the bankruptcy court, which is in our favor. They affirmed the district court with regard to Michelle Zollner's guilt by finding her fully culpable for injuring Dr. Collins by wrongfully converting his secured property to evade the judgment. Let's see. It went on to say that, gosh, I hate to really get into this because it's really so important. Just suffice it to say that next we're going to continue this, and you're going to see what the actual crux and express reasoning between the courts was for this particular bankruptcy fraud cases in our next segment, which we are going to cover next week. It's part 2. And so we're going to go back over the Zollner Big Red Barn bankruptcy issue where the landlord was defrauded and how that is now in the Fifth Circuit. I'm sorry, the United States Supreme Court, and over the D.R. Horton case where there's a title dispute on some land that belongs to somebody, but not Horton that they're building on. And so, knowing that, be sure to tune in next week, Tuesday at noon, to hear the rest of the story, as they say. And most importantly, remember to serve God by serving others, and we will see you next week.